It is just observation that Prime Minister and Chief Minister should not give a post of minister to any such background person charge sheeted. There were 40 cases. Some cases were even serious. And one law was introduced, and by that cases were withdrawn. Right to reject, we do not have right to reject. This is also one electoral reform suggested. Should citizen have right to reject? So there are some people who vote to a candidate who is winning, not a losing candidate. Means by 2022 September, we had still 4,442 criminal cases. Are they effective, such guidelines? So in 2000, let's say that they have given, then again 2014, let's say that Manoj Narula case, then 2020. Basically they say details. Antecedents you have to give, assets you have to give. This within 48 hours you have to publish. So do you think that they are effective? They will just, let's say, it will result into increased awareness. It will increase awareness, let's say. Rather than having, let's say, any serious impact on the life of people, that they will not vote them. Yes. And it is just observation that Prime Minister and Chief Minister should not give a post of minister to any such background person charge sheeted. But do you think they will they will that is what we can consider, like when they talk about. Then let's say the Supreme Court says that any person who has a criminal background, let's say candidate, charge sheeted candidate, it says this basically. They say that you should not give, why you have given ticket to a criminal background, let's say that the person, within 48 hours you have to publish, why you have not given ticket to other candidates, why you have given ticket to criminal background. Do you think they will follow it? That provision. Said. Basically in 2021, you know that contempt code, contempt of court. Supreme Court issued contempt of court to BJP and Congress. This because in Bihar elections, basically they did not adhere to this order. This you can consider. So that we can take in terms of when we're talking. And a point was coming in my mind. Somehow it is. Yes. It was coming like they say that cases should not be withdrawn. Without high courts. This they have told in 2020. Sorry, 21. You know that why this judgment has come? When Yogi ji became chief minister, There were, let's say, before Chief Minister, there were 40 cases against him. And an ordinance was brought and all those cases were withdrawn. Yes. By an ordinance. It is like Nayak movie. Have you seen Nayak movie? Right. Amrish Puri comes back to power and an ordinance is issued and all the cases against him, right, he tries to withdraw. Yes. So this is a trend, let's say, those who are having criminal cases, when they are coming to power, the governments are trying to withdraw criminal cases against them. This. One living example is Uttar Pradesh Chief Minister. This. There were 40 cases. Some cases were even serious. And one law was introduced and by that cases were withdrawn. You cannot talk all these things because you know that they are beyond comparison. In fact, they are themselves incarnation of Ram. So we cannot talk them. This when you bring that kind of thing. And who will dare to challenge that law in Uttar Pradesh? You know that. कौन जाके चैलेंज करेगा हाई कोर्ट में? Anyhow, 2014 case. So this they say that कि nota, but nota is not effective. नोटा का लेट्स से बेसिकली ये जन चौकीदार केस है, इसको जन चौकीदार केस भी बोलते हैं. 2 केस आया था 2013 में, इसको कि लैंडमार्क बोला गया फॉर एड्रेसिंग क्रिमिनलाइजेशन ऑफ पॉलिटिक्स. राइट. दिस पीपल यूनियन ऑफ सिविल लिबर्टी केस या जन चौकीदार केस. बेसिकली ये केस ऐसा था that those who were in detention that time, those who were in detention, those who are in jail, right, and the detention, so they were not made eligible to cast their vote. Those who are in detention, they were not eligible to cast their vote. This. Therefore, the court, let's say, the court in the judgment passed that those who are in detention, they would also not be able to contest election. This, it was considered as a good judgment. Those who are in detention, those who are in jail, they will also not be eligible to contest their elections, since citizens are also not eligible to cast their vote. Government ने क्या किया? Government made citizens eligible to cast vote. Judgment is nullified. Right. ये एक बहुत अच्छा जजमेंट था कोर्ट का, जिससे क्रिमिनलाइजेशन कम होता है, बट गवर्नमेंट ने उसको नलिफाई इसलिए कर दिया कि सिटीजन्स वर अलाउड टू वोट. यस, दैट वाज जन चौकीदार केस. However, government introduced, let's say, कि citizens can have right to reject this. Now, right to reject, we do not have right to reject. This is also one electoral reform suggested, कि should citizen have right to reject? They should not have right to reject. Rather, they have, let's say, it is complex. Last day means Monday, I will bring you question answer type, some of the things I will talk electoral reform. So basically, here we say that citizens, they can have the option of, let's say, none of the above. When they go for vote, they have candidate, and then they have also one option, none of the above. Right. even citizen has none of the above option, and most of the voters in a constituency, right, go for none of the above, is still the second highest, let's say that vote a candidate is getting is declared winner. So when a candidate who is getting second highest, the highest is none of the above, so still the candidate is winning. So when candidate is winning, so what is the logic of nota? Will citizen exercise nota? They will say it is wastage of my vote. It is a flaw, and it was introduced to, let's keep pilot basis to see how it works. But it does not work. This, because this anyhow candidate is going to win. Then citizens have one concern, you know that. And citizens have one thinking, whether his vote is going to play any role. You know this voting behavior. Citizens also think whether his vote is going to be wasted or his vote is going to be counted. So there are some people who vote to a candidate who is winning, not a losing candidate. वो यही सोच के जाते हैं कि मुझे जीतने को जिताना है, मुझे हारने वाले को वोट नहीं देना है. ये होता है कि हारने वाले को वोट नहीं देना है. तो जब वो नोटा पे क्यों करेगा, वो तो उसका वोट और भी वेस्ट हो जाएगा. तो दिस जजमेंट इज आल्सो ऑफ नो इफेक्ट. Nota, let's say that it is not as effective, you can say. Lily Thomas case also we have told. The Lily Thomas case, let's say that or 2013 it is. Lily Thomas, if you say so, you know that only 3 MLAs were disqualified. Its effect is very less. So then fast track court वाला judgment वो भी लेते हैं. See, fast track court, if you remember, we taught, you know, fast track courts are not necessarily fast track. तो फास्ट ट्रैक कोर्ट वर्क करेगा जब आप रिसोर्स दोगे, तब तो वर्क करेगा. राइट, आप जज अपॉइंट करोगे, उनको रिसोर्स दोगे, तभी तो वर्क करेगा. राइट, 2020 तक का जो ये रिपोर्ट आया था, जब कोर्ट ने गवर्नमेंट को फिर से वो किया था, तो 2020 तक का रिपोर्ट ये है कि दिस 2020 में जब रिपोर्ट आता है, तो इट इज दैट देयर वर 4,442 क्रिमिनल केसेस and let's say involving 2,556 sitting members of parliament. Means by 2022 September, we had still 4,442 criminal cases. Let's say that we had MLAs or MP, now which let's say half can be considered as MPs. Means even fast track court was supposed to be constituted since 2017. Still you know that cases are pending, because even fast track courts are not necessarily fast track. Yes, that judgment is also, let's say that it means even if the reforms which have come from judicial side, but those reforms are not very effective to tackle the menace of criminalization of politics.